Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Rhysa Iris Ewonia, and today I'll be taking you through the changes that have been introduced with the passage of the new Land Act of Ghana, which is the Land Act 2020 Act 1036. On the 23rd of December 2020, the Parliament of Ghana passed a law which was the Land Act 2020 Act 1036, and it was assented to by the President on the same date. The new Land Act, which was enacted, was stated in its preamble to revise, harmonize, and consolidate the laws on Ghana to ensure sustainable land administration and management, effective and efficient land tenure, and to provide for its related matters. It's important for you to understand that prior to the Land Act 2020 Act 1036, there were several enactments which were in relation to land and its matters. And for you to get a comprehensive understanding about land and its issues, you needed to read on each of these enactments to know what the law requires of you. With the passage of the new Land Act 2020 Act 1036, Section 282 of the Act repealed certain acts of Parliament and stated that these acts were no more applicable in the country. Examples of such enactments as stated under Section 282 are the Land Development Protection of Purchases Act 1960 Act 2, the Farmlands Protection Act 1962 Act 107, the State Land Act 1962, the Land Registry Act 1962 Act 122, and a few others. So you need to understand that these enactments have now been repealed with the passage of Act 1036. With that being said, it is important for us to now delve into the changes that have been introduced with the passage of the new Act. However, you should note that changes do not necessarily mean that novelties have been introduced. Certain things were already in place, but they have been revised or they have been changed. But some also were new things that were introduced into the Land Act. An example of a novelty that has been introduced with the passage of Act 1036 is the criminalization of land guards and their activities. The law now provides that a person who unlawfully exercises control or supervision over development of a land in a location, or that person has no interest in land, yet extorts money or other benefits from a person with interest in land, or prevents a developer from developing the land, commits an offense and on summary conviction may suffer a term of imprisonment or a fine or both. Again, a person who uses or through another person uses force, violence, or intimidation to prevent or obstruct a lawful owner of land from developing their own land commits an offense, and that individual may suffer a term of imprisonment or fine or both upon summary conviction. This particular provision is captured under Section 12 of Act 1036. So previously, there was no law that criminalized the actions of land guards in relation to the land that is owned by persons. But now, with the passage of this new act, it states that if a person does any of the activities I mentioned, which could be preventing an owner from entering his land or developing his land, that individual has committed an offense, and that individual can suffer a term of imprisonment or pay a fine. So the activities of a land guard is now an offense which is punishable under the law. Another novelty that has been introduced with the Act is the prohibition of discriminatory practices. In tune with the 1992 Constitution of Ghana, every transaction will be rendered as void any decision or practice in respect of land under customary tenure which discriminates on grounds of place of origin, ethnic origin, political opinions, color, gender, occupation, religion or creed, or any of these factors that have been mentioned. Under Chapter 5 of the 1992 Constitution of Ghana, there is a specific prohibition on persons from discriminating against other persons based on any of the factors I mentioned. And this particular prohibition has been emphasized under Section 11 of Act 1036. So I encourage you to read the provision to get a better understanding. Also, under Section 12, subsection 4 of Act 1036, the law allows a person who has an interest in land to institute an action by way of an interlocutory injunction against an unknown trespasser on the same land. So if someone comes to your land and you do not know the person and the person is a trespasser, the law permits you to institute an action against that person to restrict him from entering your land. As I stated in my previous video, Section 50 of the Land Act introduced or talks about the covenants that are in relation to land, specifically leases. However, Section 50 of Act 1036 has expanded or generated innovative implied covenants in relation to land that a person must necessarily know. So, the Section 50 states that where a lease in respect of a bare land is granted by a person who holds an allodial or usufructory interest in the land, and the lessee is an indigene of the area where the land is situated, the lease is subject to automatic renewal where the lessee has developed the land for residential purposes, or farms perennial crops on the land, or has a commercial or industrial property on the land for the same duration as the original lease. So if you have created a lease interest and you are an indigene within the area in which the land is found, and you have developed the land either for residential purposes or to farm perennial crops, there is an implied covenant which says that the lease is subject to automatic renewal. So it's a novelty that has been introduced that you must know. Under the same section, the Act also states that unless the parties expressly provide in the lease, where bare land is leased to a citizen of Ghana who is not an indigene of the area where the land is situated, there shall be an implied term in the lease that the lessee is entitled to a renewal of the lease. So this is quite different from what I mentioned earlier, in the sense that in this particular one, you need not necessarily be an indigene, but you must be a citizen of Ghana. And the renewal is not automatic, unlike the previous one. It is subject to a renewal, but it's not automatic that immediately happens. It must be renewed. Another novelty is a lease of bare public land granted by the Republic to a citizen of Ghana is subject to automatic renewal on terms agreed upon by the parties. Note, however, that this automatic renewal is inapplicable in situations where the lease in respect of a commercial property or the lease property is required for redevelopment. So that is a novelty that has been introduced with the passage of Section 50. Another novelty that has been introduced with the passage of the New Land Act touches on the usufructory interest, and it states that the holder of the interest is proscribed from alienating any interest in the land to a person who is not entitled to that interest without the written consent of the allodial title owner. Previously, it was under the law that the usufructory interest can alienate his property to another person, and he does not need to seek permission or the consent of the allodial title owner, which I explained in my video on usufructory interest. However, with the passage of the New Land Act, specifically Section 50, subsection 2 of Act 1036, it states that the usufructory interest needs to get the written consent of the allodial title owner before they can alienate the property to any other person. Also, the Act gives legal recognition to long peaceful occupation of land by non-indigenes or group of non-indigenes or their descendants on the land for a period not less than 50 years. So even if you are not an indigene but you're a Ghanaian and you have stayed on the land peacefully, with the passage of Act 1036, you can assume the position of a usufructory interest holder under certain circumstances. Another change that has been introduced with the passage of the Land Act 2020 Act 1036 is a restriction that has been placed on the creation of freehold interest. As I stated earlier, the Constitution has prescribed persons from creating freehold interest, but there was no statutory provision in relation to that particular provision of the Constitution. So now, persons are prescribed or they are restricted from creating freehold interest to other persons. Also, it is now a requirement for a spouse to obtain the written consent of the other spouse before selling, exchanging, transferring, mortgaging, or leasing the land or property they own, right or interest in the land, or entering into a contract for the sale, exchange, transfer of the said land, but the consent that the spouse needs from the other spouse should not unreasonably be withheld. So now, with the passage of these new acts, you, as a spouse, you need the written consent of your other spouse before you can transfer any property you own, if it's a joint property. I spoke extensively about this on my video on spousal rights, so I encourage you to watch that video. The new act also gave clarity on juristic persons who are non-citizens as regards the acquisition of interest in land exceeding 50 years. The new act states that a company or corporate body held by individuals who hold more than 40% of its equity shares is classified as a non-citizen, which is therefore a foreigner. By virtue of this particular provision, as I stated earlier in my previous videos on allodial title and usufructuary interest, a foreigner cannot hold an interest in land in Ghana exceeding 50 years. That is stated under Articles 265, 266, and 267 of the 1990 Constitution of Ghana. So such persons cannot hold property exceeding 50 years. By the passage of this act, if the company has a foreigner who holds more than 40% of its equity shares, that company will be classified as a foreigner, and therefore that company cannot hold an interest in land exceeding 50 years. A novelty that has been introduced with the passage of this act is that the occupants of stools are now fiduciaries and they are accountable to their subjects. Section 13 of the Land Act 2020 Act 1036 talks about this extensively, and it even extends the fiduciaries to chiefs, tindanes, and clan heads. Prior to the passage of this act, there was a Head of Family Accountability Act that was in existence, which made heads of families accountable to the members of the family if there is any transaction in relation to their family land. The case of Kwan Enyeni also gave certain instances when the head of family will be found to be accountable, and also it's granted instances where members can institute an action on behalf of the family if the head of the family cannot do so. Many people were of the opinion that that particular law, which made heads of family accountable to their members of the family, should not be extended to chiefs and tindanes. But with the passage of this new act, it has been extended to them, and these people are expected to be accountable to their subjects for any transaction in relation to the said land. Another novelty that has been introduced is that no alienation of an interest in allodial land shall be made unless the land has been registered. Any transaction in relation to land pursuant to Section 32 of Act 1036 must be in writing, and Sections 34, 35, and 36 of the same Act state that the written document must be signed by the parties, and it must also be registered in accordance with the Act. So now, if there's any transaction that is made by an allodial title holder to another person, he must ensure that the land which is stated in that transaction is registered for that particular transaction to be effective. Another novelty that has been introduced with the passage of this act is that states can now acquire allodial title upon compulsory acquisition. Section 2 of Act 1036 gives examples of persons or institutions who can acquire an allodial title, and it made mention of states. Previously, it was chiefs, individuals, families, and clans, and tindanes who could acquire the allodial title. But now the states can, if they compulsorily acquire the land. If that is done in accordance with Article 20 of the 1992 Constitution of Ghana, the states will be the allodial title holder, and it can deal with the property in accordance with the law. Another novelty that has been introduced with the Act is that if a person unlawfully occupies a public land, it does not create any interest in that person, who in this case will be a trespasser. There is a particular principle of law, which is adverse possession, which states or which gives permission to persons who do not own land to acquire an interest in the said land if a particular limit or certain conditions have been met. However, with the passage of this new Land Act, it expressly states that any person who unlawfully occupies a public land does not acquire any interest in that same land. This particular provision of the Land Act flows directly from the case of Memuna Mudi and Entry, and I encourage you to read that case for a comprehensive understanding of adverse possession and how it relates to public lands or lands that are owned by the state. Another novelty that has been introduced with the passage of this act is found in section 268 of Act 1036, and it states that it is unlawful to vest clan or family land in the state. It also states that similarly, it is unlawful to vest stew or skin land in the state. So now persons are proscribed from vesting any of these lands in the state. Section 73 of Act 1036 also gives a leeway or permission for land to be conveyed electronically, depending on certain circumstances. But it's important for you to remember that any transaction in relation to land must be in writing. So even if you transfer the interest electronically, you must also ensure that you have a written document that evidences the transfer of the interest in land. Another novelty is that certain issues that may come up in relation to land can be resolved through the use of dispute resolution. The Land Act has given an expansive provision or provisions on dispute resolution. There are numerous provisions for the adoption of alternative dispute resolution under the Alternative Dispute Resolution Act 2010 Act 798 as a preferred mode of dispute resolution. Some of the provisions are permissive while others are mandatory. A novelty that has been introduced with the passage of the Land Act 2020 Act 1036 is a creation or the establishment of a customary land secretariat. This particular office did not exist prior to this act, but now the law under sections 14 to 18 of Act 1036 has created the customary land secretariat, and it is mandatory for a customary land secretariat to be set up by the customary landowners to manage stew, clan, skin, or family lands. They are also required to keep records of customary land transactions, whether they are oral or documentary. So these are the various changes that have been introduced with the passage of the Land Act. I hope you have understood them and you relate it to whatever you have been taught in class if you're a student. Thank you for joining us in this wonderful session. Kindly do not forget to like, comment, subscribe, and share our videos to your friends and your peers for them to understand the changes that have been introduced with the passage of the Land Act 2020 Act 1036.